Hey guys, what is up? I'm Aditya Kashyap and I came up live again with part 2 of Bharatiya Saksh Adhiniyam MCQ series. So, in this lecture, we will solve MCQ from Bharatiya Saksh Adhiniyam. This is part 2 of our series, and this series is going to help you in your judiciary and APO examination. So, let's start, but before starting the series, let's recall some of the facts which are very, very essential for Bharatiya Saksh Adhiniyam. So, Bharatiya Saksh Adhiniyam is an adjective law, that is law of procedure, and it consists of 170 section. The erstwhile Indian Evidence Act 1872 consists of 167 section, and it got presidential assent on 25th of December 2023, and it came into force on 1st of July 2024. So these are the facts related to Bharatiya Saksh Adhiniyam which we must keep in our mind. Okay, so चलिए शुरू करते हैं MCQ series part 2 भारतीय साक्ष्य अधिनियम which is going to be very very useful and helpful in your upcoming judiciary and APO exam. So guys, the first question of Bharatiya Sakshya Adhiniyam: which of the following does not constitute evidence within the meaning of Section 2 of Bharatiya Sakshya Adhiniyam? So which of the following does not constitute evidence within the meaning of Section 2 of BSA? So tape recording of conversation. So it is evidence considered. Okay, affidavit is not considered evidence. So the correct option is option B. इलेक्ट्रॉनिक रिकॉर्ड प्रोड्यूस फॉर इंस्पेक्शन ऑफ कोर्ट ये भी होता है. ऑल डॉक्यूमेंट प्रोड्यूस्ड फॉर द इंस्पेक्शन ऑफ कोर्ट तो ये भी होता है. सो द करेक्ट आंसर इज ऑप्शन बी. इट इज नॉट इंक्लूडेड इन द definition of evidence under section 2 of Bharatiya Sakshya Adhiniyam, right? Question number 2. A tried for murder of B. ठीक है, A tried for murder of B by intentionally beating him with a club causing his death. Okay, which of the following fact are in issue? So A beating B with club, it is fact in issue. ठीक है, A is causing B's death by such beating, तो ये भी fact in issue है ना. और A is intention to cause B death, तो ये भी तीनों essential issue है. So all are correct option, right? So let's move on to question number 2. Question number 2. Bharatiya Saksh Adhiniyam does not expressly mention about. So Bharatiya Saksh Adhiniyam does not expressly mention about circumstantial evidence. Okay, oral evidence, documentary evidence, and secondary evidence. So these three are mentioned in the Bharatiya Saksh Adhiniyam, but the circumstantial evidence is not mentioned in the Bharatiya Saksh Adhiniyam. Okay, so the correct option is option D. चलिए आगे बढ़ते हैं क्वेश्चन नंबर 4 की ओर. क्वेश्चन नंबर 4 क्या कह रहा है? An inscription on a metal plate is, so an inscription on a metal plate is a document. Okay, so it will come under the definition of document. Okay, question number 5. A is accused of child murder. The following facts are constructed in the case. So the following facts are constituted in the fact case. So an hour before the mother, A went to the place of the murder with the child. ठीक है. A alone returned home. ठीक है. Collar of A's shirt found on the blood stained. The evidence which take into account the above mentioned fact is called. So these are called circumstantial evidence. Okay, so all the three are essential fact, and this is called as circumstantial evidence. तो आगे बढ़ते हैं क्वेश्चन नंबर 6 की ओर. इनकरेक्ट स्टेटमेंट को मार्क करने के लिए बोल रहा है. ठीक है. तो व्हाट इज द फर्स्ट स्टेटमेंट? तो फर्स्ट स्टेटमेंट है द टर्म रेलिवेंसी एंड एडमिसिबिलिटी आर को एक्सटेंसिव और इंटरचेंजेबल. सो क्या ये इनकरेक्ट है? ऑब्वियसली इनकरेक्ट है ना. सो द फर्स्ट ऑप्शन इज इनकरेक्ट. द टर्म रेलिवेंसी एंड एडमिसिबिलिटी आर को एक्सटेंसिव और इंटरचेंजेबल टर्म नहीं. ठीक है ना. सेकेंड क्या है? ऑल एडमिसिबल एविडेंस इज यूजुअली रेलिवेंट बट ऑल रेलिवेंट एविडेंस इज नॉट एडमिसिबल. ये भी सही, ये तो सही है ऑब्वियसली. रेलिवेंसी इज द जीनस ऑफ विच एडमिसिबिलिटी इज अ स्पेसिस. ठीक है, ये भी बात सही है. रेलिवेंसी इज द जीनस ऑफ विच एडमिसिबिलिटी इज अ स्पेसिस. सो क्वेश्चन और डी भी क्या कह रहा है? रेलिवेंसी एंड एडमिसिबिलिटी आर नीदर सिनोनिम्स नॉर इज द वन इंक्लूडेड इन अदर. तो ये भी सही है, राइट. तो द करेक्ट जो इनकरेक्ट स्टेटमेंट कौन सा हो गया? स्टेटमेंट ए. क्वेश्चन नंबर 7. क्वेश्चन नंबर 7 क्या कह रहा है? Circumstantial evidence is considered weaker evidence as compared to direct evidence. ठीक है, ये बात तो सही है. तो क्यों सही है? इसका explanation क्या होना चाहिए? Because it has two errors of fallibility. ठीक है? Because it has two errors of fallibility. First, of the fact from which inference is drawn being proved, and of the inference to be drawn from the fact proved. Okay, so this is the correct explanation. ठीक है, because it has to of the fact from which inference is drawn being proved. ठीक है ना, जिस fact से inference drawn किया गया उसको prove करना होगा, and of the inference to be drawn from the fact proved. और inference हमेशा कुछ से drawn किया जाएगा जो fact proved हो गया. तो इसीलिए circumstantial evidence क्या होता है? Considered as a weaker evidence as compared to direct evidence. Okay. So let's move on to question number 8. Question number 8 क्या कह रहा है? A fact under section 2 of भारतीय साक्ष्य अधिनियम means and include. So a fact under section 2 of भारतीय साक्ष्य अधिनियम means and include anything capable of being perceived by senses is the correct answer. B कह रहा a state of thing capable of being perceived by senses, ये भी आ जाएगा अधिनियम के अंदर section 2 में. And relation of thing capable of being perceived by senses. So all three are the correct fact. मतलब ये included in the section 2 of definition of fact. Okay. So D is the correct option. Question number 9. Question number 9 क्या कहता है? Proposition under भारतीय साक्ष्य अधिनियम are. Question number 9 कह रहा है proposition under भारतीय साक्ष्य अधिनियम are. पहला, presumption of fact is always rebuttable. ठीक है, ये तो एकदम सही बात है ना. प्रिजम्पशन ऑफ फैक्ट जो होता है ऑलवेज रिबटेबल होता है. प्रिजम्पशन ऑफ फैक्ट कैन बी इधर रिबटेबल और इररिबटेबल. नहीं, ये गलत है ना. तो फर्स्ट राइट, सेकेंड इनकरेक्ट. ठीक है. थर्ड क्या कह रहा है? प्रिजम्पशन ऑफ लॉ आर ऑलवेज इररिबटेबल. तो थर्ड क्या है? थर्ड भी गलत है ना. प्रिजम्पशन ऑफ लॉ आर ऑलवेज इररिबटेबल. नहीं, ऐसा कुछ नहीं है. ऑलवेज इररिबटेबल नहीं होता है. And presumption of law can be either rebuttable or irrebutable. So the fourth is correct. So first is correct and fourth is correct. So option किसमें है? Option B में सही mention है. So the right answer is option B. So this is question number 9 of भारतीय साक्ष्य अधिनियम. क्वेश्चन नंबर 10 of भारतीय साक्षर अधिनियम क्या कह रहा है? Under BSA, as a general rule, what is a general rule under BSA? So, opinion on a matter of fact is relevant but not on a matter of law. तो ये बात तो सही, opinion जो होता है वो relevant होता है matter of fact पे, matter of law पे opinion relevant नहीं होता है. So ये correct है statement under भारतीय साक्षर अधिनियम as a general rule. So question of 11 क्या कह रहा है? Which of the following is not a fact? तो among the given option, which is not a fact? So mental condition, क्या ये fact है? Obviously it is a fact. Relation of thing, ये भी ठीक है. State of thing, ये भी fact है. None of the above. So not a fact. तो ये सारे fact हैं, तो none of the above हो जाए, है ना? Not a fact. Question number 12. Which one of the following has not been mentioned in the definition of document? So इनमें से क्या definition of document में mention नहीं है as the means by which any matter is expressed or described upon any substance. So later document में आ जाएगा, फिगर भी आ जाएगा, मार्क्स भी आ जाएगा, सिंबल नहीं आएगा, ठीक है ना? सो डॉक्यूमेंट में लेटर, फिगर, मार्क्स मेंशन है, सिंबल मेंशन नहीं है, ठीक है? 2D में डॉक्यूमेंट आता है. आगे बढ़ते हैं क्वेश्चन नंबर 13 पे. क्वेश्चन नंबर 13 क्या कह रहा है? व्हाट इज द मीनिंग ऑफ नॉट प्रूव्ड अंदर भारतीय साक्षर अधिनियम? तो नॉट प्रूव्ड का मीनिंग होता है नाइदर प्रूव नॉट डिसप्रूव. सो द करेक्ट ऑप्शन इज ऑप्शन डी. नॉट प्रूव्ड का मतलब होता है नाइदर प्रूव नॉट डिसप्रूव एंड द करेक्ट ऑप्शन इज ऑप्शन डी. क्वेश्चन नंबर 14 क्या कहता है? 14 कह रहा है द एविडेंस unearthed by the sniper dog fall under. The evidence unearthed by the sniper dog fall under, so it will fall under scientific evidence. Okay, so correct option is option D. Question number 15 क्या कह रहा है? All statement which the court permits or required to be made before it by witnesses in relation to the matter of fact under inquiry is are. So all statement which the court permits or required to be made before it by witnesses in relation to the matter of fact under inquiry is are. So it is oral evidence. Okay. The correct option is option B. Question number 16. Question number 16 क्या कहता है? Which of the following is not included in the expression court under the भारतीय साक्षर अधिनियम? So court में इनमें से क्या? Obviously arbitrator नहीं include होता court के definition में, है ना? Judge होगा, all person legally authorized to take evidence ये भी आएगा, and all magistrate तो ये भी आया court के definition के अंदर. But arbitrator does not fall under definition of court. In the absence of substantive evidence, question number 17 पूछ रहा है, in the absence of substantive evidence, so in the absence of substantive evidence क्या होता है? Corroborative evidence has no worth, ठीक है ना? और क्वेश्चन नंबर 18, though the contempt proceeding are judicial proceeding, the strict rule of evidence contained in Bharatiya Sakshya Adhiniyam do not apply to proceeding under the Contempt of Court Act because of summary nature of inquiry. Okay, so Bharatiya Sakshya Adhiniyam do not apply to the proceeding under the Contempt Act because of summary nature of inquiry. So this is question number 18. So this is all for today. Bharatiya Sakshya Adhiniyam Part 2 lecture of MCQ series. So If you like it, do like, share, and subscribe. We will meet again with part 3 tomorrow. Bye. Take care. This is Aditya Kashyap signing out.